Hello, Michigan Realtors, and welcome back to a new year and a new installment of Letter of the Law. Today's segment will discuss illegal kickbacks under RESPA. Now, Section 8A of RESPA provides that no person shall give and no person shall accept any fee, kickback, or thing of value pursuant to any agreement or understanding, oral or otherwise, that business incident to or part of a real estate settlement service involving a federally related mortgage loan shall be referred to any person. Now, most realtors are aware that this provision of RESPA prohibits a per referral payment arrangement. For example, it is illegal for a title company to pay a salesperson an agreed upon amount for each customer that the salesperson refers to that title company. Some realtors do not understand, however, that it is also illegal for the salesperson to receive such a payment. Moreover, an illegal kickback does not necessarily involve a payment per referral arrangement. Any thing of value provided in appreciation for the referral of business pursuant to an agreement or understanding may be an illegal kickback. A thing of value can be construed broadly. For instance, shares of stock which are not paid for but which are given for free in exchange for past business or anticipated future business would be a thing of value given for the referral of business. Furthermore, an agreement or understanding for the referral of business need not be spelled out in writing, but may be implied by the conduct of the parties. Consider the following hypotheticals. First, Mary Smith, a licensed agent, has decided to open her own real estate office. Now, Mary has been referring her clients to XYZ Title Agency for years and is likely to continue to do so. XYZ Title Agency has extra space in its office building, which it agrees to lease to Mary Smith at a rental rate far below the market rate. While Mary Smith's discounted rent is not expressly tied to either past or future referrals, a court is nonetheless likely to view this bargain lease as an illegal kickback arrangement. Number two, XYZ Title Agency has developed a very good business relationship with top producing salespersons from a number of brokerage firms around town. Now, these salespersons are very loyal to XYZ Title Agency and over the years have referred many of their clients to XYZ Title Agency. In recognition of the support of these salespersons, XYZ Title Agency has offered to provide each of these top producers with a small ownership interest in XYZ Title Agency. Now, even though the ownership interest is not tied to any future promise to refer business, this is likely to be considered an illegal kickback arrangement. While there is nothing wrong with a salesperson owning an interest in a title company, the ownership interest must be based on the actual investment in the company and not on past referrals or expected future referrals. Number three, ABC Mortgage Company and XYZ Title Agency participate in some joint advertising, which is paid for solely by XYZ Title Agency. In addition, from time to time, XYZ Title Agency provides loan officers who work at ABC Mortgage Company with free tickets to sporting events and weekend getaways to various resort locations. Although there is no formal agreement, either written or oral, loan officers at ABC Mortgage Company often refer business to XYZ Title Agency. Again, this is likely to be viewed as an illegal kickback arrangement in violation of RESPA. Number four, mortgage broker encourages its borrowers to employ Attorney Smith in connection with their home purchases. Attorney Smith provides legal services to mortgage broker at abnormally low rates. A court is likely to conclude that the discounted legal services were an illegal kickback pursuant to an understanding between mortgage broker and Attorney Smith. Now, it is important to remember that RESPA does not just apply to real estate licensees and title companies. RESPA prohibits referral fees exchanged among settlement service providers. Settlement service providers are any services provided in connection with federally regulated residential mortgage loans and include things like property surveys, appraisals, home warranties, inspections, and homeowners insurance. To summarize, An illegal referral arrangement need not involve an agreed-upon quid pro quo calculation based upon the actual number of referrals. An illegal referral argument need not involve a formal agreement, but may be established through a standard of practice over a period of time. Any thing of value, including free or discounted services as part of an unspoken understanding that the recipient will send business your way, is a RESPA violation. Finally, while there is nothing wrong with a real estate licensee owning an interest in a title company, that interest cannot be based upon past referrals or expected future referrals. Many in the settlement service provider world worry less about possible RESPA violations because they believe that the government is not currently focused on RESPA. Now, even if this is true, that does not mean that the RESPA rules should be ignored. First of all, the government's focus can change without warning. Additionally, class action lawsuits are still being filed. Defending a class action lawsuit is very expensive, and Realtors should continue to take the RESPA prohibitions very seriously. Violations of RESPA can result in civil lawsuits, including class action lawsuits, where licensees can be required to pay treble damages as well as attorney's fees and costs. They can also result in fines of $10,000 and imprisonment of up to 1 year for each occurrence. So I hope you have found this segment helpful. As usual, we'll be looking for your feedback for future installments. So please send those thoughts to the email appearing on the screen or embedded in the video description. Thanks so much for watching, and we'll see you next time.